content standpoint can be difficult. But when you layer on top of that all the legal aspects of social media, it's overwhelming for most. So today we're going to get some great answers about that and some great thoughts. As far as questions go, feel free to jump in as you have questions. Plus, we'll have time for questions at the end. And I think you're going to get a lot out of today. So I'm going to ask Paul Arney to come up here. Paul Arney is a partner with Morris, Manning & Martin, and he's in their technology law section of the Georgia Bar. And it was his idea to pull this together. He knew that you guys would benefit from it. And he also chairs the pro bono effort for the technology bar. So he's the perfect person to introduce our guests and talk about what we're going to work today. Thank you, Paul. That's possible.
Thank you. Well, it's great to be here. Thanks for all of you coming. I'd like to give you a little bit of background as to how this happened. If you're a lawyer, you have to be a member of something called the Georgia Bar Association. That's not an option. But there are different sections of the Georgia Bar that you can join. And so there's a real estate section, there's a corporate section, there's all kinds of different sections. But there's one called the technology law section. It used to be the computer law section, but computers stopped being as important back when they introduced the internet. And so there are members of the technology law section, and it's kind of hard to find things for the technology lawyers to do to actually contribute back to the community. So the idea is that we're trying in the technology law section to partner with folks who serve nonprofits for the purposes of actually allowing us to contribute whatever information we may have. So this is kind of the first of the grant experiment. We're very happy to be here, but also hopefully we'll be able to, if you have other things that you're interested in, talk to James, talk to other folks at TechBridge, and we may well be able to accommodate what you folks are looking for. So hopefully this is the first of many. I actually would like to introduce the other speakers. In the middle over here is Valerie Warner-Dennis. Valerie is from a lot of different places in the United States. She actually went and did her undergraduate work at the University of British Columbia. Then went to Emory for law school. She has been involved with a number of nonprofits over the years, and actually is also a certified international privacy professional. And she actually currently works for a company called the Rocket Science Group. They run a number of email services like MailChimp, TinyLetter, and Mandels. She also says that she spends her days dealing with everything from international privacy filings to writing disclaimers for the backsides of adorable chimp plushies. So quite a range. Bruce Sarkisian is an associate at Alston Burt. Bruce actually went to Stanford, got his undergraduate degree in American Studies, is that right? Yeah. And then actually went to Columbia, got a master's in journalism, and then apparently saw the technology light, and went to work for a large provider of technology outsource services for the global Fortune 1000. After about 12 years of that, he decided, well, law school sounds like a good thing, so he went back to law school. So he's got sort of an interesting career. Just one second, guys. One, check two. You guys hear me on the speakers? Check one, check two. Hey. Okay. Continue. All right, great. Bruce does a lot like I do in that he's involved in technology transactional work, outsourcing type work. He does privacy type work as well. And so it's great to have Bruce here. Bruce is also on the executive committee of the technology law section, along with me. So I'd actually like to start out by telling you folks a story. I was asked to give a speech on the emerging law of the Internet in 1995. Now, looking at the youthful faces here, please do not tell me what you were doing in 1995. I don't want to know. But at the same time, to give you a sense of what it was like back then in 1995, talking about the emerging law of the Internet, one of the things I had to do was I actually had to explain to the lawyer. I mean, this is a national seminar. There ought to be people who know what is actually going on. I had to explain to them what the Internet was and what it meant. It was just within a few years of the first graphical user interface for the World Wide Web to come out. And the nice thing about the presentation is actually as a result of this one thing. In roughly July of 1995, I did a Lexis search for some law. Everybody familiar with Lexis? It allows you to do a word search of reported cases in the United States. So I looked at every state reported case in the United States and every federal reported case in the United States, and I searched for one word. That word was Internet. I was just looking for any case that used the word Internet in any context in a case. And I brought the search here. It's right here's the cover page. Here's the first page. That's it. I mean, there were literally 15 cases in the United States at any level that ever used the word Internet in 1995. And so this was, the nice thing about speech was, nobody's going to disagree with you because there's no law. I mean, there's nothing, the world is your oyster. You can talk about whatever you want to. And so that made for a fun speech, a great time. But to give you a sense of what was going on, there actually were two cases that had been decided by the time I gave that speech. And I want to talk to you a little bit about both of them. One was, by the way, the big Internet giants back then, we might want to now call them dinosaurs, but the big Internet giants were America Online, CompuServe, and Prodigy. Those were, if you wanted to get Internet access, those were pretty much the three that you had to use. And so there were two lawsuits. One was a lawsuit by a guy named Cubby against CompuServe, and the other one was a case, Stratton Oakmont, which is a company, versus Prodigy. And both of those cases were defamation cases. And to give you a little bit of legal background, from a defamation standpoint, what happens is that if you say something about someone and it's false, and it hurts somebody as a result of that, then you've got a potential claim. Now, the interesting thing about defamation is that it's the person who's talking is actually, it doesn't even have to be the person who said it in the first place. It's whoever is speaking or whoever is publishing at that point. Those are the people who are liable. So, for example, if I say something defamatory about James, and it gets picked up by the AJC, the Atlanta Journal-Constitution will be liable, First Amendment issues ignoring for a moment, but the AJC runs the risk of being liable for publishing a defamatory statement that I say about James. So it's this notion of publishing or speaking, even if it's a repetition of somebody else, that's when you can get into trouble from a defamation standpoint. And so what happened in Cubby versus CompuServe is there was this discussion group on CompuServe, and somebody said something about some people, and it was alleged to be wrong, and it damaged them, and they were upset, and so obviously that Cubby had a claim against the person who said it. Now, that's kind of anonymous, kind of hard to deal with, and actually the case was very similar with Stratton Oakmont versus Prodigy. Same thing. Somebody said something in a group. It was alleged to be false and defamatory. In the case of Stratton Oakmont, it was about something that was what would now be called pump and dump, or you sort of disparage something because you're getting ready to sell the stock, short or something like that. So very similar fact patterns. What was different in the fact patterns was in Covey versus CompuServe just said, hey, here it is. We're not going to look at it. We're not going to pay attention to it. We're not going to moderate it. Just here it is. And in the Stratton Oakmont case, Prodigy actually had a moderator. They were looking at it saying, if there's bad stuff in here, we want to get rid of it. And what happened was the court in the Covey versus CompuServe case said, well, if you weren't looking at it, you told folks you weren't looking at it, you're not moderating it at all or anything like that, there's no duty on your part to moderate it. And as a result of that, we're going to treat you a lot like, a bookstore would be. I mean, you don't prosecute bookstores for defamatory information that's contained in the book. And so they said, no liability on the part of CompuServe at all. And then in the Stratton Oakmont case, they said, well, you had somebody who was moderating this thing. And so maybe there's a situation where you accepted the responsibility to moderate it, and you didn't do a good job, and because you were moderating it, you had a duty to do the right thing for people. And so maybe there's a claim there. Now, let's think about that for a second. So the folks who were doing nothing had no liability. The folks who were actually trying to do the right thing had potential liability. This, from a society standpoint, may not make sense. Now, around the 1995 area, there was also this Congress said, hey, there's this internet thing. We've got no legislation about this internet stuff, and it concerns us that we don't have any legislation about it. And, they were worried about things back then. They were worried about things like pornography. The classic kind of things that you would think that the legislature would start worrying about, they started worrying about. So they actually passed this law called the Communications Decency Act. And not surprisingly, virtually everything about pornography was unconstitutional has been struck. I mean, there's virtually nothing left of this act called the Communications Decency Act related to pornography or any kind of content. But what they did do is they addressed the issue that arose in Covey and Stratton Oakmont, and they actually put a specific section in there which is now called the Safe Harbor under the Communications Decency Act, or CDA, and now you get to read some real law. That's it. That's the whole thing. Other than some what defined terms mean, that's the whole section related to this. And it says, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So if you're the one like AOL or CompuServe or Prodigy, and you're having a place what other people put information in, then you're not treated as a speaker or publisher. At least not AOL, CompuServe, and Prodigy. Still have liability if you're the speaker of it originally, but you've got no liability. And that sounds like an interesting balance. It doesn't mention anything about moderating or not moderating. It just says, if you're the one who's not actually the speaker here, if you're just republishing stuff or providing a form, you don't have liability. So let's see where that went. Then there actually are a couple things that you need to know about this particular law. One is that it does not cover crimes, so that's been accepted out of that safe harbor. And then also intellectual property also is accepted out of that. So copyright type stuff doesn't apply here. And actually, Valerie's going to talk about the copyright stuff because that's dealt with in a separate way. So anyway, there's an exception there. So let's talk about where this went. The first case is Zoran versus AOL. This one happened in about 97. The Communications Decency Act was passed in 96. Somebody just really did not like Ken Zoran. He lived in Seattle and did have an AOL account. He worked his own business out of his house, so people would just call him, and that was kind of his business. And somebody put up on AOL an offer for sale, things like coffee cups, T-shirts, you know, that type of thing. And this was actually just after the Oklahoma City bombing. Remember the Alfred Murrah building, you know, killed a lot of people. Timothy McVeigh was the one who was ultimately prosecuted and convicted for that bombing. There actually was a daycare center in there where a number of kids were killed. So anyway, the T-shirt said things like McVeigh for president. There was another one that had a picture of the Alfred Murrah building as destroyed, and underneath it said, "Finally, a daycare center that can keep the kids quiet." Not a very nice. I mean, all of these things were incredibly offensive. They were just inappropriate. Now, the other thing that happened was there was a radio station in Oklahoma City that picked this up. So all of a sudden, they're broadcasting out about all of this abusive stuff. And, you know, in the message, it was like, you know, if you want to buy one of these things, call Ken. Call Ken at this number. And it actually had his real number in it. Well, Ken ended up, and he can't really change the number because his business depended on that number. So it's not like it was easy for him just to, you know, change his phone number or something like that, because that would turn off all of his business. I mean, it was really kind of a nasty thing to do to somebody. And it ended up that he was getting abusive calls, death threats, that type of thing, to the tune of about once every 2 minutes. He had to get police protection. I mean, it was just totally abusive. He had no idea where this came from. None. Now, you can just imagine him calling up AOL and saying, "You've got to take this stuff down. You know, found out about it. You have to take this stuff down." I said, "That's fine. Are you the one who put it up?" No. Well, you know, if you're not the one who put it up, then we got to check with the owner to make sure that that's okay to put up. So there's a little bit of delay associated with that as well. And so Zeron sued AOL and lost. And the reason for that is that in the Communications Decency Act, it says that no provider of an interactive online service will be considered the speaker or the publisher of information that comes from another online content provider. And so the Communications Decency Act actually prevented AOL from being sued in this context. And you know, one question would be, was that the right thing or not? But that's the law. And actually, if the AJC had published it, the AJC would have been liable. So it's actually, it's like real life, except there's an exception in the internet world that actually exists that does not exist in real life. So let's come up with another one, Carafano versus Metro Splash. There was a woman whose real name was Carafano, and she was a character. Her stage name was Chase Masterson. She ended up being the character Lita on Star Trek Deep Space Nine. I don't know if any of you know or have heard of this person or not. But, you know, she was a kind of a C-level celebrity. And she lived in California with her son. And somebody in Germany went to one of these dating sites, Matchmaker.com, and pulled a picture or so of her off the internet and put it up as a profile picture and said that it was Chase Masterson. And then it said, you get to answer some questions in the profile. It was like, why are you here? And the answer was, I'm interested in a one-night stand. And then in the description that was sort of write whatever you want, there was stuff that said, well, I really kind of like the idea of a man just dominating me. Kind of suggesting a rape scenario, that type of thing. And then actually there was an email address. No, there was a home address, an accurate home address on the site. And there was an email address. And the email address went to a place, and then when somebody sent an email, it came back and said, are you really the kind of person who should respond to this? I want you to prove it. She had no idea that this had been put up. None. She had to move out of her house. She got threats against herself, threats against her kid. I mean, just really tremendously ugly things happened to her as a result of somebody randomly, I mean, not randomly, but somebody she had no idea who it was, no idea, not even from this country, and all of a sudden she has to move out of her house, have death threats, and worry about the safety of not only herself but also her son. So she sued Metrosplash, the owner of the Matchmaker.com site, and she lost. And she lost because the Communications Decency Act says that a speaker or a provider of information content will not be considered the publisher or speaker of somebody else's content put on by an online provider. How about sex trafficking? What do you think about that in terms of getting protections under the Communications Decency Act? The Village Voice had these classified ads at the end, and the classified ads, actually there was some suggestion that they were actually escort services. So there was a lawsuit brought against the owners of the Village Voice, claiming that they were engaged in sex trafficking, and the Communications Decency Act said that there's no claim. Now, it doesn't, and actually the StubHub case, that's for scalping tickets. You know, there are laws against scalping tickets. Is that something that the Communications Decency Act would protect against? And the answer is yeah, the Communications Decency Act prevents that from happening as well. The Yahoo case actually related to not the web, but it related to email. And the court held that email was also provided by an online content provider. And as a result of that, the things that were said by somebody else through that also did not apply. And then finally, there was this Craigslist has, you know, if you want to rent apartments or something like that, you can do classified ads on Craigslist. And there's this law called the Fair Housing Act. And the Fair Housing Act says that you just can't advertise for housing in the United States and publish advertising that attempts to make distinctions based on certain suspect categories like race or sex or national origin or religion. Those types of things you just can't do. And so again, if the Atlanta Journal-Constitution publishes something like that, they're the publisher, they're the ones who accrue a lot. And so there were these ads that went up that said things like, you know, minorities just would not like it here. You know, good Christian women only. You know, there was stuff that absolutely facially violated the Fair Housing Act. And the answer is that Craigslist was not liable as a result of the Communications Decency Act. So let's talk about kind of the limitations associated with that. There was a case that came out just a little bit after the roommates.com case came out. After the Craigslist case came out, called roommates.com. And the roommates.com case was very similar to the Craigslist case, except it did a few things that were different. And one of those things that was different was they had this filtering. So if you said that I want a roommate and I'm only looking for a male, then it would filter. When somebody was coming in, they would get a profile of them. And if they were female, it would not forward the information to somebody only looking for a male. Or if you were looking for gays or not gays, you only forwarded the stuff that met the criteria of the person who was offering the place. And you could actually pick from a list. If you had, if you hit the little list of gays only, females only, males only, you could make those kinds of choices, and they actually implemented that in the technology. And one of the interesting things about that is that remember where it says that no speaker of or no provider would be considered to be the speaker or publisher of something that somebody else said. Well, who wrote the gays only thing? I mean, you know, roommates.com wrote the gays only thing. So in some sense, they were the speaker of stuff that actually implemented the violation of the Fair Housing Act. But at the same time, there were other things that were done, like filtering. That was some stuff that you could not do. However, if somebody wanted to just put a narrative in a box at the bottom, that was okay, still, based on the Craigslist case. So there are some limits associated with what you can do. I mean, you can't like encourage people to violate the law. That just doesn't make any sense. And then also the vote versus opinion court. This was an interesting one because if there was bad content, you just let them know about the bad content, and for a fee, they'll take down the bad content. And the court said, you know, don't do that. You know, the protection only goes so far. And so let's kind of give it some thought as to what all this means. You're a nonprofit. So you are the information provider that's getting the third-party content. You guys are actually, in this scenario, the ones who are protected by this statute. And so, unlike real life, online, you actually have more protections against bad things happening than you do if things happen outside of the internet. Again, ignoring copyright, ignoring crimes and the like. But at the same time, you know, take a deep breath. You know, there is a fear, I think, of many people associated with, well, can I, you know, what if there's something defamatory that happens, or what if this happens, or what if that happens? And the answer is, you know, you actually have more protection online from a legislative standpoint right now than you do in other areas of real life. So just, you know, relax. But at the same time, don't do dumb stuff. I mean, don't charge people for taking defamatory stuff off of your site. I mean, you know, don't stick stuff in the face of violating the law. I mean, that just doesn't make any sense. Doesn't make any practical sense, and the courts aren't going to, you know, let you do that. So, you know, take a deep breath, relax. You're probably going to be okay, but at the same time, don't be stupid about it. So let's talk about. Does anybody have any questions before we go forward? We'll have lots of time for questions at the end, but at the same time, if not, we'll move to Valerie. Great.
Okay, good morning. So after that, we're going to talk a little bit about copyright law and what you can do to protect yourself and some of the basics behind making those evaluations when you are faced with copyright. So before we get started, let's do a little test. So by show of hands, how many people think that this is copyrighted? Okay, you? All right. Yeah, so when you saw the lawyers raise their hand, it is. So this is a photograph. Photographs are generally copyrightable. They have some sort of things about them that make them unique in that many people can take the same photograph of the same building, and so it's about arrangement and some of the elements that you're providing to it. So there is a more nuanced test for that, but generally a good rule of thumb is when you're looking at a photo, someone probably owns the copyright in that, so you want to be careful about reproducing it. We'll talk a little more about the specific photo later, but how about this? Show of hands, who thinks that this lovely lady is copyrighted subject? Okay, a few more. So Barbie actually is. She qualifies as a sculptural work. She is a doll, her image, and we'll also be talking about her and her litigious owner in a little while as well. So what about this? This is a blog post I wrote recently regarding our change in terms. Show of hands. Okay, a few more again. Yes, lawyers. Yeah, so literal writings, this is definitely going to qualify. And then I have a little video that I have to. Who's using music? But good idea. So what about this video of adorable cats? Show hands. All right, so less people are convinced, but believe it or not, these adorable cats would trigger some copyright, could trigger copyright, because if you look at it, normally there'd be music that has been synced to this, that's a copyright in and of itself. Then you also have the composition of this, someone went out and shot these individual shots, edited them together and created a new work. The hat they're wearing is our MailChimp hat for cats, just if you're wondering why you're in the video entirely about cats, that's why. And, yeah, so my point of all of this is that there is some bad news today, this morning. I'm sorry to be the bearer of bad news, but most things you encounter on the internet are copyrightable. This is true, as we've just seen, pretty much everything I've shown you could trigger copyright. And the worst news is that copyright infringement occurs when you copy a protected work in any way, and that even if the finished work is different. So if you just take it as an intermediary and then finish with something completely different, if they can prove that you had that as an intermediary, so if you're using it in storyboards and then you draw over it, this has happened with some animation cases, that would be liability. So you have to be really careful. And the other thing about it is that the damages for copyright infringement, this is protected by federal law, and so they're set by statute. They can be adjusted on individual factors, but they can range from anywhere between $750 to $30,000 per work. So each individual work that you take could trigger liability, and it can be up to $150,000 per work if you're a willful infringer, which is a higher burden where you have to prove some other factors, but can also be something that you may get in a cease and desist letter where they'll threaten something like that. So to get started, copyright basically it protects works of original authorship, both published and unpublished, and it does not require a notice. Although when you look at things, you'll most often see the name of the author, a copyright symbol, circle C, name of the author, and the year. This isn't required, but it's a good idea because you start putting people on notice that what you're producing is copyrighted. The time when copyright is protected is when it's fixed in a tangible medium, meaning when it's written, when it's drawn, when it's taken, when that photo is snapped, and that's when you get a copyright. You don't have to register it. You don't have to do anything. You have that copyright at that moment. It's a good idea to register it, and I'll go into more of that later, but it does occur at that moment. It doesn't protect basic ideas. It only protects that particular expression of an idea. And it must be original. It must have some degree of creativity. This is why tweets sometimes are arguably maybe not copyrightable because 140 characters is so limited. There's only a certain number of ways to say things. So there are limits, but generally if it's an original sort of expression of an idea or of creative areas, that it will be protected. And then there are things that are not under copyright law. If they're not under copyright law, they're in something called the public domain. And once something goes into the public domain, it never comes back out because copyright is a finite period of time, although recently it's getting longer, as you will see in this slide. So if you look at the graph, it kind of shows how long copyright has been protected since it's been protected in the United States. The first U.S. statute was in 1790. It's provided under the Constitution to protect copyright, to promote progress of science and useful arts. The idea is that by doing this, we are encouraging creative individuals to create things, because if they couldn't get some sort of benefit from it, then they would stop creating. And that's the whole theory behind why we have copyright. So you can see it's gotten longer. It first started with 14 years, and then the 14-year renewal, that eventually became 28, and then now we're up to 100 and some odd. And so funny thing is they tend to get extended anytime Mickey Mouse comes up for going into the public domain. So there are people who are very invested in making sure that their copyrighted material does not really fall into the public's hands. Another thing that is the Digital Millennium Copyright Act, and that's important because it criminalized some infringement and it created a service provider exemption, which I will also talk about later, and created a notice system. So as I've kind of talked about, these are the types of work that copyright covers. So literature, musical compositions, movies, audiovisual works, sound recordings, architectural works, photographs, derivative works. Derivative works are when you create something off of another copyrighted work. So when you have your copyright, if you write a blog post and then you want to repurpose it into an article or a book, that's a derivative work of the first thing that you copyrighted. But it's in your right as an owner to do that. Dramatic works, choreography, and then, as I said, pictorial, graphic, and sculptural works. There are some content that you can't copyright. As I said, ideas or scenes of fare, which are things that are like very common. So basic plots of sort of romance novels, or some of those specific things that occur so frequently, like you're in medieval period time and there's a damsel in a castle. Like you're not going to be able to get protection over that. Nothing is useful items. You can see a wine cork here, corkscrew. So those would be protected under patent or other sort of laws. It doesn't really make sense to put them under copyright. And then, as I said, derivative works beyond people's copyrighted things. Works by the federal government, those don't tend to go into copyright because they're being produced, with all of our money, and so that's where that is. And non-fixed works, so a garden or anything that's growing or moving or changing. If it's sand, sculpture, those kind of things. If it's not fixed, then it's not going to be covered. And facts, because otherwise you can have news and all that kind of lovely things. So a bit of gloss over this, but there are a bundle of rights when you get to copyright. It's not just one right, it's a bunch of rights. It's the right to reproduce it, the right to create derivative works, distribute it, to do public performances of the work, to make a public display of the work, and then also depending on what kind of work you're getting the copyright in, some of these rights you won't have, or some of these rights will be more important. So it's really a bundle of rights, and you want to have as many as possible, and you can license some of them and keep some of them, and it can get sort of tricky there. So the owner of a copyrighted work is the person who created it. Now, this can change in a few different areas. One is where you have a joint work. So let's say that you and your friend are producing something together. If you don't have an agreement or any understanding, you both contribute to this material that is copyrighted, like say a movie or a drawing. You draw some of it, he draws the background or something like that. You are joint authors of that copyright, and you both have the right to exploit it and do things with that work. You just have to account for each other for any profits that you make. So the important thing here is when you're collaborating with people, you really need to have an agreement or some sort of understanding as to what you expect, because otherwise you end up in a situation where you both can do whatever you want with it. And the only thing, so you can't stop them from putting it, they want to put it on YouTube, you can't stop them from putting it on YouTube. If they make any money off of YouTube, you can ask for half of it, but you can't stop them. So think about who you're working with. Another example is work for hire. So if you have employees or interns or someone who's entered into an agreement with you, if they're producing that work, you've asked them to do it, and that would be assigned to you. So your organization would have that copyright, regardless of the fact that someone else made it. But again, that needs to be, it needs to be the scope of their employment, and generally you would like a writing to discuss that so everyone's aware. Independent contractors can also create works for hire, but they must be one of these 9 categories, and again, there must be an agreement in writing. So the moral of all of this is, when you're working with other people, make sure you have some sort of agreement, because if they're producing copyrighted work for you, they may be getting some rights in addition to that. So some steps you can take to protect yourself. One of them is I talked about the Digital Millennium Copyright Act, and what that does is it created a service provider exemption, and so you can file. It's easy. It's $105 plus $30 for any additional names. I have forms up at the table, so please take one if you're interested in it. You just mail it in. It's designed for kind of what we're talking about, platforms and what what Paul was talking about, where you have sort of people who are providing a space for others to interact. And so part of that is to allow them, if there is something up there, so if someone's copyrighted work ends up on your website or ends up in an email campaign at my company, that copyright owner knows who to contact. That's the point of the designated agent. They know who to contact. In my company, it's contacting me. So they send me a notice saying it contains certain things, saying this is a copyrighted work, it's available here, we are the owner, we did not allow this to be put on your website, take it down. And if you take it down within a reasonable period of time, you're not liable. So that's the good news, is that it creates this sort of way for you to accept user content without opening yourself up to so much liability. So you have to do a filing. Here you can see the filing. It's very basic. It's one page. On the left is the blank form. On the right is the one that I filled out for my registration. If you need, this one's amended because there was someone registered as our designated agent prior to me, and so you can update it at any time. You have to pay a fee again, but it's good. You also would like to probably put this information on your website somewhere so that people can easily access. It's listed on the copyright.gov website, so someone can just go there and look for it, but it's always, if you can make it easier for people to find you and contact you, it kind of helps. So there's that. The other thing is probably filing registrations for copyrighted works that you're creating, particularly ones that you think are more public or you expect to perhaps be lucrative for others to copy. Filing registration is very, very easy. You can do it online. It's cheaper to do it online, so it's just doing that way. You go to the copyright.gov. And the reason why you should register is because even though you get a copyright when you create the work, that fixed time when it becomes, that picture or that writing, you can't enforce it in federal court. And that's the only place that copyright really matters. So in order to sue someone over it or really start taking some steps, you need to have registration. You can register at any point. You don't have to register when it's done, but if you, normally registering is $35. It's very cheap, but if you, for some reason, are about to enter in a litigation, you can rush it because it's a government office and it could take a couple of days, it could take a couple of weeks. But if you need it in a couple of days, you really have to pay sort of an extra fee, and that's closer to $800. So it's a low cost to protect these works. There's several different forms you have to file under the form that makes the most sense. So there's literary work, work of visual arts, sound recording, works of performing arts, motion picture, single serial issues, and those sort of things. So you can register multiple works together as long as they were published at the same time. And then when you file your application, you're going to do whatever the basis, like what the most of the work is. So for example, we provide email guides that kind of tell people specific things that they need to be worried about. Like, here's some basics about spam laws. When we provide these guides, they're mostly a literal work. They have a lot of text. They also have some design elements. They have some images. They have some covers. But I register that as a literal work because it is mostly a text-based work. Yeah. So another thing you can do is use copyright-friendly resources. So try to use resources that have been created by you or an employer or contractor, maybe appear under a Creative Commons license, or available in the public domain. Flickr, for instance, does have a service where you can search the comments. So if you go to flickr.com and you say hit explore, there's a little drop-down menu and you can search in a particular area. So you can search, they have the Getty collection, and then they also have something called the comments. And these are places where they say, to the best of our knowledge, these copyrights are not valid. Now, there is a little bit of risk there. There could be something mixed in there that is copyrighted still, but overall they tend to be government collections and older photos. So for example, the photo I opened with of that dog, that was actually taken in 1900 and I got from Flickr, and it, for all intents and purposes, seems to be without copyright. So I can use that feeling more secure than if I do a Google search and just take a picture from Google Images, which is not a good idea. I do not endorse any of you doing that. The other one I talked about is Creative Commons. So Creative Commons is an organization who decided that we need an easier way to communicate licenses. And this works both ways. It's a good way to provide works that you maybe want to make available for people to use. It's also a good way to find works that you might want to use. And they tend to fall into, there's 6 or 7 licenses, and they have, on the left, you can see they have sort of a summary that is just, here are the basics of this. What you can do, you're free to share, you can remix it, you can change it, create derivative works, but you have to provide attribution, and you can only do the non-commercial aspects. That changes depending on the license. You can see that they have little icons. Some of them are no derivatives, no commercial. Some of them are commercials okay. Sharelight. A lot of them will do this Sharelight, which means you have to make whatever you make available for other people to use under the same license. So these are important. You can read. You can quickly sort of get an idea of what you're allowed to do with these works. On the right, you can go to the full long license, which is better probably to send to an attorney than to muddle through because it's a very long license. But they do try to be clearer. So those are a good resource. So I sometimes get questions about, oh, well, I can use 17 seconds of music and that's okay because copyright isn't triggered, or I'm commenting on this so it's okay because that's fair use. So let's talk about fair use. First off, it does not matter what percentage of a copyright work you take. If you're using it, there's no 17-second cutoff, there's no magic number, there is no portion of that. There is a doctrine called fair use. the most important thing about fair use is fair use is a defense. So what that means is that when someone says, you have infringed my copyright, and they file a lawsuit against you, you're not going to get to raise this defense until a little ways down the line. So you're going to have to pay to respond, you're going to pay to do some discovery, and then eventually you're going to be able to make your defense fair use, and it may go all the way to trial. So it's an expensive proposition to rely on, because if you have to take it, you're going to have to present it before a judge. So it is a defense against copyright infringement, though. It's based on a variety of factors, so it's not an easy black or white. There's no clear law to just say, this is what they say. The factors are the purpose and character of use. So are you using this in a commercial context? Are you using it for, in a nonprofit context? Are you using it in an educational way? And so those vary. Obviously, commercial would weigh against fair use, and educational or nonprofit weighs sort of for fair use. The other is the nature of the copied work. So are you copying something that is entitled to very strong copyright protections? Is it something very unique? Is it something that is, well within it, or is it something closer to facts? Is it something closer to, there? So the other factor is the amount and substantiality of the copied work used. So how much of this work have you copied? How much have you used? And then it's not just that, it's what is the substance of your use. So for example, when President Ford published his memoirs, he had a section about Watergate. And that was all that people cared about his book. And so a newspaper took out that chapter, just took out that chapter and published it. And so even though it was a couple pages of a 300-page book, they were found liable because that is the heart of the book. It was so important for the sales of that book. It was, substantially, it was that work. And so it doesn't matter if it's a few pages, if it's the most important part of it. And so that also is the last factor, which is the effect upon the potential market for the copied work. So in that example, it made it much harder for his sales to go well. The key word for all of this is, are you making a transformative use? And so a good example of that is, again, let's go back to Barbie. And so Aqua, in the late 90s or early 90s, came out with a song called Barbie Girl. Hope you all are familiar with it, but, come on Barbie, let's go party. And it was, this kind of pastiche of Barbie, and they're singing about that sort of thing. And so Mattel got upset because it became a big hit. And so they sued them. And it came down to, Aqua is making a transformative use of Barbie because they're using Barbie as sort of to comment on this idea of femininity and this idea of sort of materialist society and that kind of thing. And they can only use Barbie. It only works because it is Barbie. Everyone knows who Barbie is. She represents something. And so for that reason, it was a transformative work. It's not like Barbie's going to put out their own kind of pastiche record of, Barbie running around and being sort of, ditzy and drunk. That's not going to happen. So there is sort of that area. So Barbie also tried to sue an artist who created some pictures of her like in a blender and Barbie enchiladas, and it was protected for the same reason. It was a commentary on Barbie and sort of, American society and that sort of thing. So commentary is usually a stronger position to be in fair use, but it is a variety of factors. So social media networks, which is where a lot of you are interacting with copyright in addition to your website. And the first thing to be aware of is that all social platforms have terms of use. And they're going to say different things about how you can use their service and what they do with what you put up on their service. And so you want to read those, because if you're putting content up on Instagram and they're saying we can sell to ad networks, that may not be what you want to have happen. So definitely be aware of, sort of what they're allowed to do. A lot of it's going to be hidden in privacy policies because that talks about the sharing of your information. They should also probably have something in the terms that discusses that. So, read it. There has been public outcry. Instagram is a good example. They changed their terms, and if people were assuming that they were having the right to be able to sell pictures to ad networks. And everyone got all upset and said, no, you can't do that. They have to change it back down. So it's important to keep track of that because terms for social networks also change. So they usually will post it to their website or they will send you an email, and so you need to be aware of that and take a look at what's happened because some of those changes could materially impact what you've done, and there may be a time limit where you can object or need to get your content off of their servers prior to those terms going into effect. Another example is Twitter. Twitter, under their terms, allows anyone to reproduce tweets so long as they have conform with their brand guidelines and have certain attribution, make sure they don't obscure your name or do anything like that. So that's something to be aware of. Twitter treats it as a public sort of statement. The other thing is, just because you see it on Facebook or Pinterest or Instagram does not mean that someone has consented to that happening. It does not mean that they are waiving their copyright. It does not mean that you can reshare or reuse or redo whatever you want with it, because someone down the line could get upset about that. And so just because it's viral does not mean that it's okay. To what degree they enforce that varies. An example is the Harlem Shake. That one has some copyright issues, and the individual who actually made the sound has some issues because he did not get permission from the compilations. Now, so some of the individual who, from some of the samples, so the companies behind the samples are now starting to decide whether or not they want to pursue litigation related to that. So another example is on social networks. They may provide you templates or stock images or things you can use, and you want to be sure that you can use that. If you want to take that to your website or you want to do something else with that, make sure that you're allowed to do that. So that varies. For example, at MailChimp, we provide email templates, and we license them under a Creative Commons license. So we allow people to use them in specific ways, and we make that public. But sometimes they only use it on that service itself. So even though you have permission to use that copyrighted material on their service, if you then use it in a way outside the license, you could be liable. Yeah, that's the end of the very basic overview of copyright law. Does anyone have any questions? Okay.
There seems to be some changes about Library of Congress now and usage for quote-unquote public domain there. How do you even find out?
Yeah, so generally if it's, you can go to libraryofcongress.gov and see what they say on it. It's varying. I know that it's difficult to find out, but you can sort of do a couple of things. If it's created by the federal government, it's not going to be copyrighted. If it's appearing in some sort of collection, if it's past a certain age, so you can see with copyright there is a certain time period where things have completely dropped off. So anything before 1900, you're probably doing okay. So there is time limits. I know that recently Obama announced that he is going to be releasing a lot of the scientific papers into the public domain for the same reason that a lot of government works are made available, because this is being produced with government money, and there's a reason and a good reason to make that available to the public. So yeah, your best options are to stay up with the Library of Congress and then look at other sort of areas like Flickr or other services that are aggregating things that are in the public.
Does Flickr have a pretty good handle on, or are they going to be like everyone else was like, hello, we're just here?
Yeah, so Flickr is never going to, like, if you get sued and you try to join Flickr,
right?
Flickr is going to say, well, we had this disclaimer that we thought the copyright was okay-ish, and we should not be liable for this. But to some degree, it's also, they are providing it. They're putting it up there with sort of the idea that it's in the commons, the wording, so you could maybe bring them along for the ride, but the odds are that they're going to get out because they are a service provider and they are providing it in sort of a...
Well, I mean, most of the ones that I've read, when you get down to the usage and all that, it's like basically we're not going to be liable.
Yeah.
It's all going to fall on you, and they continue to write that, and they don't give you like any real guideline other than go do your research and find out where it came from. And I'm not saying that you shouldn't.
Well, you remember all these licenses are being written by lawyers, so no one is going to allow a client to put forward a license where it says, oh, if you use it, we'll be liable for it. No, they're not going to do that. So part of it is doing your homework, and part of it is sort of using it and making sort of yourself available in DMCA areas where you can receive a takedown and then act accordingly, because if you're acting in good faith to take it down and you're a service provider for that period, then you should be fine. So it would be more if you're using it maybe in a way that's off the internet, so on a poster or those sort of things. And it's going to be the same with employee agreements. Like if you're going to have someone create something, you really need to have them represent a warrant that they are creating it and they're not ripping it off, because that happens a lot too, is people will provide to you a copyright, a work they have based off someone else's copyright, and then you use it, and that's going to still be problematic for you. So,
Let me have one other question.
Sure.
Okay, if we are creating content, be it training material or content that we would like to copyright,
mhm.
then would we go to the copyright website and copyright those, be it video, print, PowerPoint slides, things like that? And should that also be present, like on the actual video screen, so that people know, even should they embed it in there?
It's always a good idea to put a copyright notice on there. As I said, it's not required. You don't have to do it. You don't have to lose sleep if you forgot to put it on there. But it is a good idea to have it on there so people are on notice, that you can say they should have been on notice. This is obvious that it was copyrighted. For registration, yes, you would be registering it with the copyright.gov, and it varies on, what you think. I know budget is tight, can be tight, so what you think you want to copyright in that area, and which ones you don't want to. But it's definitely a good area. The registration doesn't get you any additional rights, it just allows you to enforce your rights in federal court. So
MailChimp, if they wrote a series of guides
yes.
for publishing content or what have you, and you all put a copyright on those,
Yes.
those would be considered, like somebody, honest to God, it is amazing sometimes. People will just go into a document, pick up all the text, change the names, and then...
Oh, I see it. I mean, we have a lot of competitors that just do that. I mean, they do it in foreign languages, translate our entire guide into a different language, use the exact same images. Websites, you can copyright web design, so I've had to copyright websites because I have copycat sites, and some of those are really nefarious because they're pretending to be us to try to lure people into entering information. So there's a lot of things that copyright can help you protect, and so that I do. I register all of our guides, I register our website, I register all images created, I register every movie created. I do that also because we're a larger target. We send 2 billion emails a month, we have 3 million users, so there's a lot of people who want to take our content and do something with it, and I have a legal budget, but at the very minimum, things that are very public and you think are very crucial to your nonprofit you should register.
Yeah, and actually, let me give you just a little bit of clarification on a couple of things. The first one is, let's use your Flickr example. Let's suppose that I have a Flickr account, because I do, and I've taken pictures and I've uploaded them to Flickr, which I have. And there's no copyright notice on it, nothing like that. You have.
Well, you can, in fact, post copyright notices on Flickr.
Well, you can, but let's suppose that I didn't, because, I didn't. And so there's this Flickr out there. You can actually see some of the pictures that I've taken. You go to my thing, there are pictures there. There's no restriction on you downloading it. I mean,
right.
Flickr will allow you.
That's the problem.
Will
There's
allow you
no
to download
restriction
it.
to download. Yeah.
But let me suggest, here's how the rights work. When I take the picture, as soon as that picture hits my compact flash disk, as soon as it hits that little beacon, it's copyrighted, not copyrightable, copyrighted.
Right.
And I am the owner of the copyright when I take the picture. Now, if I upload it to Flickr, I still own the copyright. I haven't assigned it to anybody. And in order to get that copyright to be assigned, it has to be assigned in writing. So I still own the copyright. So when you go to the Flickr site, there's nothing that can happen between you and Flickr which can affect my rights. Nothing. It doesn't matter what the terms of use are. It just doesn't matter because you can't affect my rights because you're not talking to me. Now, if I want to have more rights, if I want to sue somebody for, using my picture,
Right.
then I have to register first because I can't get into the courthouse unless I register. But that doesn't change the fact that I own the copyright.
Right.
And by the way, if I register before the infringement occurs, I also get the right to choose statutory damages for those numbers that Valerie mentioned, the damages amount. I can actually choose those rather than prove my own damages. And I may be able to get legal fees. So there's an advantage to registering copyright, but the fact of the matter is, even if you infringe and I haven't registered, I can register and sue you and get you to stop.
Okay.
Now, if I don't put a copyright notice on it, I can still sue you and get you to stop.
Right.
But what happens is my damages are less because, maybe less, because you may say, well, I'm an innocent infringer. I didn't know that was copyrighted. I didn't know you had a copyrighted map. And you'd be right. So if you put a copyright notice on it, what it does is it eliminates that innocent infringer defense. But that doesn't mean it changes the ownership of copyright. That's not necessary.
Okay, here's
one
one short question
Sure.
to throw in there. So, like, we have photographers that cover events, and we have permission from those photographers to use them at Flickr and those sorts of things. How extensive does our document need to be? And they're fully aware that somebody can come to Flickr and download them. So that part is not an
Well,
issue.
and actually that raises an interesting point. If you, in common parlance, if you say, oh, that's a work for hire, you know, we got that, that's a work for hire.
Right.
If you want it to be legally accurate about 95% of the time, just put a not in front of it, because it's not a work for hire. Because a work for hire says if you're an employee and you do something while you're being employed, then the company that employs them owns the copyright and not the person who creates it. And with very limited exceptions, that's it. So if you have a photographer who's not your full-time employee,
Right.
taking a picture, the photographer owns the copyright.
Right. That's what I'm
Okay,
generally
and-
saying.
and
So
you have-
if we have permission to use it on our Flickr site or whatever, and I have an email that says that we have complete permission to do with whatever it is we want, is that sufficient, or do I have to have a real document somewhere?
Well, one of the interesting things is that electronic documents almost always are real documents.
Okay, so it would be
They're
as
legally
legitimate as a
enforceable.
fax or a signed
Yeah,
document?
they are legally enforceable as a writing, just like a piece of paper would be. Again, with very limited exceptions. And so just get used to the idea of you can create a contract by email exchange. You can do that. And so just ignore that. But what happens is that the problem with not getting things real specific is when you start saying, well, you know, I know we got this picture for this particular, pamphlet that we created that would be really nice to put it on our website. Or it'd be really nice to use this in a campaign. And then, did you get those rights? I mean, what rights did you get? And by the way, the only way you get the copyright to it is you have to have it a written assignment of the copyright itself. Otherwise, you do not get the copyright.
Okay. Well, I don't know that I want a transfer of the copyright.
You just want a license.
We have a release to use for our intents and purposes.
And so what Paul's just saying is that you want that to be as specific as possible. So for your purposes, you want him to say, you can use this, worldwide in perpetuity for anything related to your organization. Something with that.
I like that worldwide part. In perpetuity. Okay.
In perpetuity,
Yeah.
worldwide, in any media,
Yeah.
any modifications, the right to make derivative works, the right to copy, the right to distribute, the right to publicly perform, all those kinds of words are the type of things that you might have in it. And there's also another aspect of this. Let's use this analogy again. Let's suppose I put a picture up on Flickr. I own the copyright. You take that picture and you put it in something that's actually on one of your servers. Okay, well, in that situation, if I don't like it, I then send you a notice that says, you got my copyrighted stuff. And by the way, it could have come from, Bruce could have sent it and posted it to your site.
Right.
And I said, well, that's my picture. I don't want you to do that. So I can do a couple of different things. I can sue you for contributory copyright infringement. I potentially can sue you for copyright infringement. Unless you comply with the safe harbor in the Digital Millennium Copyright Act, which means you take this little form and you fill this little form out, you pay the $100,
Right.
you filed it with the Copyright Office. This is things like what's your name, what's your address.
Yes.
It's really easy to fill out.
Okay.
So you put that in there, and then on your site, you also say, if you see anything that's copyrighted here, that that's yours, and you have a complaint, then here's where you send the notice. Because if you don't put that information on your site, you also don't get the safe harbor. And then when somebody sends you a notice, it says...
So there's no downside to doing that?
No, there's hopefully protection. But then once you get a notice, then you know, in most situations with a small nonprofit, you just take it down. You just say, okay, you get it. Okay, I'm responding to it. I'm taking it down. If it's something that's important to you, call your lawyer. I mean, because there are other issues there. But the trick is you file, you post, and any event that something happens where you find out about it, you've got to do something. You've got to be appropriate with it. And there's some other provisions about, you know, if you have somebody who consistently keeps putting more bad stuff on there that you kick them off the sites and that kind of stuff. So the requirements are more complex than what I'm generally describing. But basically what you have there is this protection against against having stuff on your site. Now, the other thing is that it's also important to note is, remember when Valerie said it was, you know, per work? That means per copy.
Whoa.
Okay, so for example, if I make a copy of a music CD, and then I send it to Bruce, and then I send it to Valerie, and I send it to James, well, I made 3 copies of it. Now that's 3 times the statutory minimum. So putting that on a web context, if you have a server, and that thing gets uploaded, it doesn't have to come from you, but it gets uploaded, and then Bruce downloads it, Valerie downloads it, James downloads it, that's 3 copies. So again, it's a per copy kind of basis for those damages. And so again, this is like dirt easy.
Yeah.
I mean, it's just, there's no reason that you shouldn't do this other than you know.
And they don't give you notice when you send it in. Just check the website to make sure you get listed in a reasonable amount of time. So you can see that it was scanned and received online, but I had to go physically check to make sure that it was put up there.
Thank you. That's very helpful.
Yeah.
If our website is copyrighted and our emails, we use MailChimp, so if our emails are copyrighted, does that mean the content on the website and the content in the emails are already copyrighted?
Yes. So I mean, when you create the content, that's as you know, Paul was talking about. That's when the copyright is fixed. So by putting a copyright notice on your emails and on your website, you're removing the innocent infringer defense. So you're allowing people, you're putting people on notice that everything on your website is copyrighted. And you're putting people on notice that everything in your email is copyrighted. But they become copyrighted at the time that they are created. Now, if you wanted to enforce those rights, as we said, you have to register it prior to doing that. So you have to do the $35 registration. Also, if you're doing it all at the same time. So on a website, if everything goes live at the same time, you can publish that. You can copyright that as one work. And then as things change, you may have to do that again. But yeah. But it's, again, you want to things like websites are great things to register because people may rip them off. And again, you would like to be able to plead statutory damages. You want to be able to get those large figures as opposed to then registering after you know the infringement and not being able to get and having to prove your actual damages, which can be more tricky, but is, of course, doable.
Yeah, and let me suggest that let's get Bruce to the talk, and then you guys can ask questions about it. So I do want to make sure we have time, because if it must, like Bruce asked, also it's very useful. So, thank you.
But I think the information that I'm going to convey to you is going to be very practical and hopefully something you can use. So why is privacy important? People now have started to realize that their personal information can be used as currency. Even stuff as simple as your name plus your zip code in the era that we're in of big data can be used to market to you, to send you solicitations. And in fact, recently there was a case in Massachusetts where they basically said somebody's zip code is their personal information. So just types of information that we once gave out willy-nilly and without thinking about it, we need to start thinking about it as valuable and that we need to protect. People want to know how their information is going to be used. So if you collect information from donors at a website, people want to know, well, what are you going to do with that? Are you going to use it to solicit me? Are you going to send me mailings? Are you going to send me emails? Are you going to call me? Are you going to give that information to maybe some other parties that you think are worthy causes, some partner organizations that may promote things that you're sympathetic with? Are you going to use it to monetize that information? Are you going to try and make money from it? Are you going to sell that information to a third party who may have a product to sell? People want to know that. And I think the biggest risk is that if you use people's information, your donors' information, your members' information in a way that they don't like, they may get angry with you and either ask you to stop contributing to your organization, discontinue their membership, any number of things. The legal view in terms of why privacy is important, there are a number of laws in a number of different jurisdictions that regulate information that you collect online. So in California, there's some laws on the books that require anybody that has a website to disclose the practices they engage in regarding the information they collect. The FTC has gone after large organizations that say, we do this with information, but we don't do that, when in fact they do that. So the FTC has brought enforcement actions against them. There's something called the Children's Online Privacy Protection Act, and that says that you cannot collect personal information of somebody who is under 13 without their parents' permission. A lot of websites targeting children, offering online games, they've gotten in trouble because they haven't gotten the parental permission as they're supposed to under the law. And recently the FTC modified the COPPA rules and made the scope of information that's covered broader. And so something like a kid's picture could now be considered personal information even without the kid's name, just his picture. And then the EU, the European Union, I don't know if any of you have a presence there or get information from individuals living in the EU, but they have very strict requirements about getting somebody's permission before you do anything with their information. So one law I wanted to highlight to you was the California Shine the Light law. And this has been law in California since 2005. And it requires organizations to disclose whether they share personal information that they collect. And when I'm talking about personal information they collect, it's anything from if you have somebody fill out a form on your website that, where you get their name and address and their email address and their phone number so you can send them stuff. Or it could even be stuff that you might collect automatically through your website. It requires you to tell people on your website with whom you share that information that you collect, if that's a third party. And you also must give people an option to opt out of that information sharing, so how they can contact you to tell you, do not share my information with third parties. And then it also states some specific information that needs to be included in an online privacy policy. Then there's the California Online Privacy Protection Act, and it requires websites collecting personal information to actually have a privacy notice on their website and comply with what they say they're going to do. And this applies to any commercial website that collects information of California residents. And when you think, well, I'm not a California company, I don't necessarily target people in California, but, as a practical matter, if you're out there on the web, it's likely people from California are going to stumble on your website even unintentionally. So it pretty much applies to everyone. Here's some tips in terms of writing a privacy policy or a privacy notice that you're going to post on your website. First of all, do you call it a policy or do you call it a notice? if you call it a policy, that could be construed as a contract and may give you a heightened obligation when you change it to actually notify people that you're changing it. Whereas a notice is, this is our practice, this is what we do, we may change it from time to time, and we always post the latest version on our website. Cutting and pasting is one of the biggest sins that is committed in terms of privacy notice development. If somebody knows generally that they need to create a policy for their website, but they don't, want to hire a lawyer, or they don't want to take a lot of time doing it, they just say, well, let me go to another website that's in a similar industry to me, or somebody that's respected. Maybe Google, they're smart, they're on the web all the time, they probably have a good privacy policy. Let me just cut and paste theirs and I'll be fine. The problem with that is that a lot of times somebody else's privacy policy says something that you may not do or you may not follow. So, for example, it may say, we use XX type of encryption to protect your personal information, and you may not have any sort of encryption at all to protect personal information. So you really have to first, you have to build your privacy policy from the ground up. You have to know what you're doing, first of all, the information you're collecting, and then what you're doing with that information, how you're protecting it, how you're using it, how you're sharing it with third parties, and that kind of stuff. And related to that is, if you copy and paste somebody's privacy policy, you may make a statement that's overly broad, and you may not even realize stuff that you're doing. So you might say, we do not share your information with third parties. Well, you may not sell somebody's information, but you may have a third-party vendor that sends out your mailings. So actually you do share information with a third party who's working on your behalf, but nonetheless, that third party has gotten the personal information that you collected on your website. So what are some elements of a good privacy notice? You need to tell people what personal information you collect. So, we collect your name, we collect your address, we collect your email address. And lately there has been a heightened sensitivity with the proliferation of mobile phones and mobile apps that even an app may collect someone's location. So, for example, if you've got a website that gives people restaurant recommendations, based on where they are at the time, they're collecting that person's location. And there's been a heightened sensitivity to collecting location because if somebody knows who you are and your location at the time, or your location at a number of different points, they can sort of retrace your life in a way that many people find invasive. How do we collect personal information and when? So you need to disclose not only the information you collect on the web, but also if you collect information offline, whether it's at events or at a fundraiser. If you get people's name and address, you need to let people know that in your privacy. How do you use the personal information you collect? Do you use it for contact information? And if so, how? Do you contact them by phone? Do you contact them by email? Do you contact them by physical mail? There are some statutes that regulate how you can contact people by telephone, whether you contact them on their mobile phone, and also with regard to email, there's something called can-spam that says, if you send them a commercial email, you have to also give them the opportunity to opt out. And also, do you contact them by text? Text marketing and text contacts are also regulated, so people need to know how you're going to contact them. Let them know how you keep their information secure. So here I would advise, just using very general language. we use industry standard practices to keep your information secure, because if you say we use such and such a product or such and such a method to keep your information secure, your technical folks may change that, and then all of a sudden you're out of compliance with the privacy notice. How do you share information with third parties? What information do you share with third parties, and when do you share it with third parties? So it's more than just you're selling names to a third party so they can market their products to that person. It could also be, in the example I gave before, you have a third party vendor who does your mailing for you, so you need to let people know that. Some of the stuff is required by the California laws. So how an individual can change their information if, for example, they have a change of address, a change of email address, change of phone number, change of name. How can they change that information with you so that the information you have is accurate and up to date? You need to let them know. You can contact us and we'll change your information. And then something you have to be careful of is a lot of times in an organization, data can go to a number of different systems depending on how you're using it and where the data is stored. And you need to make sure that once somebody changes their information, that data is corrected on all the systems where it resides. Information sharing that individuals may control. So a lot of times you'll see in a privacy notice that we collect information automatically via cookies in your web browser. However, if you may turn off cookies in your browser, and then we do not collect that information. And then you let them know what happens if they turn off cookies in their browser. A lot of times, if you turn off cookies for a website, it won't work properly, or it will work differently for that person. Your California privacy rights. So this is something that's required by the California law. You need to make it clear that if you are a resident of California, here are your privacy rights. How do we change our notice? How do we communicate changes to our notice? Let people know, we will post a new notice on this website. We will date our privacy policy. Or if you want to be extra careful, you say we will email you when we change our privacy policy. But that's a lot more burdensome. And then finally, you need contact information for how to get in touch with you to change your information, or to register a complaint, or to opt out. And generally you should have multiple ways of contacting you. And where to get more information? The FTC has great information about consumer privacy and privacy for businesses. Trustee and these other two organizations also have really good resources on how to develop and write a privacy policy and tips similar to what I've provided to you. And then just to emphasize, one size doesn't fit all when it comes to privacy policies, so be sure you build yours from the ground up. You know what you're doing with personal information before you write your privacy note. That's all I have. Any questions? Yeah.
At different times, if someone opts out of your email, anything like that, do you have to inform them that you received that, that you're just deleting them, or just by getting their email, that's fine?
Yeah, generally you should. What happens is under canned spam, you need to have a link in the email that says if you want to opt out of emails, click here. And so you click that, and it takes them to a website where either you have them type in their email address, or you've already got their email address because your system has collected it, and that website will say you are now opted out of our.
We just had people who won't click opt out. They'll email us and say, please take me off the list. I know I've been doing that. And we need to respond back.
As long as you take them off, then you're obliging their opt out. The only thing is, sometimes, or at least it doesn't, sometimes you'll get really cranky if you email them after they've asked to not receive anything anymore. So that's the only danger of responding to someone's opt out request. Just as long as you honor it within a reasonable time period.
Yeah, one of the tricks is that some people will communicate back to indicate, number one, that they've gotten the message, even though legally required. And also to set expectations, because nothing is easy in terms of technology. There's a lot of stuff that goes on with it. So it's not like you will necessarily be able to stop stuff from being sent to them for a period of time. And so you say, well, there's some stuff that we got in the queue, we can't get out of the queue, so you're going to get this, and you have to send this notice for a period of time. And so if you set expectations, that also is usually a useful thing to do. If you do it on web, you can have an opportunity to say, thank you, you got it. Here's your expectations. So that can be done that way. And so just be careful about sending more messages to the same company you want to see your website expectations. And let me suggest that any kind of question, whether we cover it here or not, we'll try to take a stab.
A question about your groups from your section. So it seemed like the advice you were giving people is if you have an online group, you're better off just not moderating it.
No, not anymore.
Oh.
Not anymore. The nice thing about the Communications Decency Act is it doesn't matter whether you moderate it or not. So do the right thing. Don't. If you can't afford to moderate it, then that's people will understand, and probably makes sense to let people know that it's not moderated and the like. But at the same time, just because you have a moderator does not mean that that content is from you. Now, if you modify the content, you make it, but again, if it's coming from somebody else, the Communications Decency Act does a pretty good job of protecting against a lot of different. Thank you.
On that same note, we have a Facebook page for our organization, but there's also a closed group that uses our name that none of our employees are a part of. But there are things going on in that closed group that people are expecting us to address, but we're not part of that group. So we're not moderating the things that are going on in that. How can we cover ourselves? Are we covered because we're not in it?
Is it operating with your consent? Like, do you want this? And it's under, is it using your name?
It's, to give a little background, I'm not taking too much time. It's for our camp program. So we have a policy that all our volunteers cannot be Facebook friends with any children under the age of 18. So it's a safe place that actually some of the kids created to connect with each other because it's a closed group and you're not friends. And so it's kind of a loophole around what I think our policy.
Yeah.
So there are adults and children in this group, but they're just in a closed forum. You have to be accepted. So it has our camp name on it, but it's not ours, and we're not part of it. What really came to light is when a bunch of negative things were being said about our organization, and then it was brought to our attention by some board members. So we haven't really known what to do as far as one of the people that created it delete the negative comments, but we don't know what to do with this group because it's not ours. And we did have an open forum where we, explained that it wasn't ours, that our official Facebook page, you can get all the information, but we're not affiliated with it. So
Can you get them to change it to like a fan group or like past camp residents or something that makes it more clear that it's not associated with you guys directly?
okay.
Well, and again, the first question would be, do you want to take it down or do you want to leave it up?
Right.
If you want to take it down, you may well have rights to force them to take it down.
Okay.
If you want to leave it up, then you're in a situation of saying, okay, we recognize that this is up, but we can take it down.
Right.
You're using our name to identify us. It may suggest that it's us. We have a trademark in our own name.
Right.
And so you have certain rights that you actually may be able to get that stuff to be taken down. So what you say is, we may be able to take it down, but we don't want liability for it.
Right.
It's okay, but we don't want liability for it. And so what we want you to do is exchange for us saying, okay, we're not going to take it down right now. Say, not affiliated with us, not monitored by us, put that up front. Make sure that that's a part of it. To make sure that that's that you're setting the appropriate notices of what actually is going on. And again, the Communications Decency Act is going to say, well, did this content come from you? If the answer is no, then
Right.
You know, you're not Facebook, you're not the provider, and that ought not be an issue. But that doesn't mean that from a business standpoint, that's something that you should do.
Right. Well, and that's really been because it's been pretty detrimental, to be honest. The things that were being said, because it has a camp program name on it, people were assuming that we would go into that forum and respond, but for a while we didn't even know it existed because we weren't members of this close group until it was brought to our attention. So.
And Facebook has an abuse center, so if you do those sort of groups appear, you can report them. And if you have a registered trademark, someone is operating under your trademark, they will review it and at their discretion take it down or reassign it. Twitter does the same thing. You can get Twitter handles if it just depends on what the use on the other end is, and that's going to be a judgment call that that platform will make.
There is a logic for knowing what's going on.
Right, yeah.
On the net, and so it may make sense to try to work. You know, you don't have to participate, but
Sure.
if things get really negative, you say, look, okay, this does not work, and we want to provide a form of our name on it
Right.
to suggest these kinds of things.
Sure.
So,
Yeah, and reactions that, because people were calling for our action in that group, but we weren't seeing it. And so finally someone posted something on our Facebook page, but it was still in that negative light. So we ended up shutting down where you can't post a comment on our page, just so that didn't happen. Because Facebook used to have an option where you could review before people posted, but they don't have that anymore. So.
I guess my question is kind of along the same lines. My organization is based in Norfolk, which is in my building in itself in terms of privacy. So we've been slow to engage in any kind of social media platform. And I'm wondering if there's any tips of rules of order, tips that we should be looking out for as we start. I think we have a presence on Facebook, but it hasn't been used in a while. And I'm fine with that. I think that I see a need for it, and obviously you can't be quiet in this world that we live in. But anything we should be looking out for in terms of how we use Facebook and Twitter probably are the two that I see other agencies like us using. Do you have any legal wisdom so that I don't end up with a nightmare like that?
I mean, you should obviously not put Facebook and Twitter, I wouldn't use anything that is sensitive or could call out members who haven't identified themselves or anything along those lines who would share sort of health history or anything related to that, or any communications related to that. Keep those as well.
Do you find closed forums work better, like the Facebook page where you're not soliciting? Have you guys had any experience with organizations running into trouble when their page is just literally an update page as opposed to a forum type of situation? I'm just wondering if there's one avenue that's better for us than another.
I mean, ours is an update area and we get some angry people, but we just respond and we have still such a volume that it just, that's part of being there, in our opinion, is being part of the conversation. We prefer people to bring it to us and be open than to have them saying it somewhere where we don't see it, but I mean, that varies. Sure.
yeah, there are no real kind of specific rules. If you have a static site that doesn't allow any information to be put up there except the stuff that you put up there, then the likelihood of you getting into having problems because of negative things said on that site is pretty low. But at the same time, it may not achieve what you're trying to achieve. If you're trying to create a community, having a static website is not going to cut it. And so, to a large extent, it's saying, what am I trying to do? And based upon what I'm trying to do, what should I do in that context, and how do I protect myself? So it can be open, it can be closed, it can be moderated, it can not be moderated. There are a number of things that you can do, but it all really depends on the start with the business issue about what is it we're trying to accomplish, what are you trying to do, and then say, okay, how do we do it?
Right, and then going back to the earlier conversation of defamation, should somebody get in a situation where they're calling out another organization and their inabilities on our space and expecting us to address it in the context of who's saying this and where is the information and the liability in terms of nasty things being said about another nonprofit or another person?
Well, we get the yeah. If you're not the provider of the information,
We're just hosting a spot.
then you're not the speaker and you're not the public. But at the same time, that doesn't solve your business problem. You've got other issues. that you need to make.
Paul, do you think it's a good practice to disclose how, sort of the rules of the road for that kind of thing, and how you're going to police things, or if you're going to moderate comments versus if you're not? Because I think generally people want to know, what are the rules on this site? What is this organization doing? Do they police, don't they? Because, if they see something that doesn't look right, and you say, well, this is an open forum, we want free and open dialogue, then they might be a little more understanding than if they don't see something.
Right.
Yeah, and a lot of this stuff is, a lot of problems occur because people aren't thinking through what's supposed to happen. So, for example, Eli Lilly had a website where Prozac users could come and share information. And
That was impressive.
well, it was interesting, but ultimately they decided they wouldn't do it. So you can just see it now. Somebody decided to cut it off. So he goes to an assistant and says, okay, send a notice to everybody, tell them that, it's there. We're not going to do this anymore. So he sent the notice and they CC'd everybody, which means every single person who signed up knew the email address of every single other Prozac user. That's just, people just don't understand what they're doing when they do it. And that costs really, what, $1.7 million, something like that, in FTC funds? Because, they had something that said, you don't share your information with anybody, and now you send it out. And so, you just need to be savvy enough, and smart enough, and thoughtful enough to actually understand what you're doing. There's a tremendous, understanding that the internet is stateless and what that means. Because that then explains why we have cookies. If I send something to Amazon.com and I say, here's me, here's how to get a hold of me, here's what I want to send, here's what I want, send it back to me. They send it back to me. You say, great, thanks for the information. Now would you send me some other stuff? And that send me some other stuff like it'll leak. Amazon doesn't know who I am. It's the second, they don't have any idea who I am. And because the internet's stateless, get information, send it out. Get information, send it out. End of discussion. So what they do is you put a little tag, a little piece of information on your computer. And when you send that little tag. And then Amazon said, oh, there's this tag here. Let me go look that up in my database. And so, oh, that's Paul. And then it keeps track of what's doing. So actually, the only way that Amazon can respond to me appropriately is my second request. My second link is to have a cookie on my site. And if you disable cookies, you can't use it. And by the way, cookies are very complicated. But again, just having basic understandings are particularly appropriate. And actually, relying on them that would be a better idea.
Question about copyright. If you have a website with constantly refreshing information, isn't copyright kind of defined as a fixed thing? I guess I'm confused how you copyright something that's always evolving, changing.
Well, it gets copyrighted when it's into a hard drive system. And that's when it becomes fixed in the medium. So if you have information that's original, you can get it from somebody else, and it's a work of authorship, and words and pictures and videos and sculptures, plays, all that. Those are works of software. Those are works of authorship. Fixed in a tangible medium, which is in a hard drive. That's copyright. And that doesn't mean you won't necessarily do anything with it. But at the same time, the copyright rules say whoever created that thing has copyright. Now, there are only so many ways to say that was a silly comment. And so the shorter the text, facts, you can't copyright your name, you can't copyright your birthday, that type of thing. There are exceptions to that. But basically, it isn't expressive, creative, original, that type of thing. And it's a hard drive. It's copyright.
And the only reason I think it probably brings up, because I was talking about, if everything is if it's static, you can copyright it all in one go. That's the only reason that would matter. So if things are changing all the time, then you have to, if you want to you can register the copyright. So if it's static, you can register the copyright for everything that's on that website in one go. But if it's not, then you have to register the individual copyrights as those content is
Well,
created.
to get the rights.
To get
the
those,
registration.
yeah, to get the registration rights, but it's copyrighted as soon as you create it. So it's only if you want to get the registration rights, which is the ability to sue and the ability to go to federal court.
That also means that it's fixed.
No, so it's fixed as soon as you create it. So as soon as it hits a hard drive, as soon as it goes anywhere, that's when it's copyrighted. That moment. When you file a registration, that's when it's registered. Does that answer your question? I mean, registration it just gives you the ability to enforce in court. It doesn't change your underlying copyright, it doesn't change anything related to that, it just changes your ability to enforce it.
One last question.
Our organization is their brick wall with Craigslist on the Boys and Girls Clubs, and we've had a lot of, they've posted fraudulent job postings for our clubs, or they can hold our banking information and are sending out checks. And I mean, our bank's aware of it, they don't hash them, but it creates a huge problem for us with just tons of calls that come in, hey, we try to get this job, and they're saying it's not you, and what do you do with Craigslist? Craigslist says, contact the FTC. FTC says, well, you contact Craigslist. So it's become a big frustration with us and Craigslist.
There's no grade, but you say, look, if you want a job, here's where you go.
Well, that's what we do,
And
but
you put on your
it affects our
website.
brand, and you can only tell one person,
And the problem is that Craigslist is like just a bunch of computers that run on a lot of people.
there's no faces,
They've
there's
only
nobody
got-
to write to and say,
I think
stop
they've only got
taking
like 30 employees
groceries.
or something like that. And so they're not monitoring content, they're not doing anything. And they have some protections under the Communications Decency Act, right? So the trick is to either find the people who are doing it, not easy, but at the same time, protect yourself by saying, okay, if it comes from here, and it's not you, that type of thing. And otherwise, it's just a hard question.
Maybe
We put it
flag
on
it.
our own website, so it doesn't help
Yeah.
when people are only
But you
looking
could
at
flag, maybe do some monitor Craigslist, because you can flag posts as abusive or wrong, and so you could just do a search in the morning, report everything that's not you, that has your name.
It's every couple of months, every year, and they, we flag them, and then they find another way to get into the system, and then we flag them again, and we carry through the process. Every time we do it.
You're gonna have to do
You identify the society problem. I mean, I ended up buying stuff at Home Depot in Atlanta with a credit card, while I and my family were literally on a plane to Peru. How did we do that? Somebody stole my credit card. I had folks actually go to Kinko's and make a photocopy and put their name on a check of my, routing number and check account number, and then start writing checks. And how do you stop that? And the answer is not very well. And the trick is just to try to identify the best ways you can to mitigate those kinds of circumstances. Don't check there.
That was
Or if you can, you're probably not going to do anything. The only way you're going to get, if you can get the information behind who's doing that, because that's the only way that's going to stop. But to do that, you have to, Craigslist is going to want a court order or something to release that information, and so it's really difficult.
If they have.
If they have it. But they would have
Yeah,
it.
we've been through all of that.
Well, thank you. Thank you, Paul, Valerie, Bruce. That was very informative. Love the stories, love all the information. If you don't mind, if you could please fill out the feedback form, let us know what you thought about today's session, and feedback for future sessions, which would be very, very helpful. And also, I'd really like to thank you guys by giving you a hand. Have a great day. And once again, thanks for